and welcome to LiveLaw. My name is Diksha Divedi. 30% of all the reported crimes against women in India are cases of domestic violence. In India, women still find it difficult to report acts of domestic violence committed on her by their family members. In the year 2005, the Parliament of India passed Protection of Women from Domestic Violence Act. Under this act, the Parliament gave power to women to seek protection orders from the courts in case she is subjected to any sort of domestic violence by a husband or his relatives. By domestic violence, I mean the violence which is committed on a woman within the family inside the four corners of the house. So if you or someone known to you is facing domestic violence or at any point in time has faced acts of domestic violence, please do watch this video. First part of this video, I would be talking about Protection of Women from Domestic Violence Act 2005, in short DV Act, and in the second part, I would talk about the process of filing a complaint under this act and what to expect from your complaint. DV Act defines domestic violence as any act or conduct by a person which causes harm or injury or endangers life, limb, well-being of an aggrieved person or her family members, either with respect to demands of dowry, valuable security or money, or any act, omission or conduct causes any sort of mental or physical injury to an aggrieved person. Who is an aggrieved person under the DV Act? A woman who's living in a domestic relationship with a husband and his family members. A woman in a live-in relationship partnership. A child living with his family. What is a domestic relationship under the DV Act? A domestic relationship is a relationship between people who are living together in a shared household and are related to each other either by birth, marriage or adoption. What is a shared household under the DV Act? A shared household is a place where an aggrieved person is living in a domestic relationship with an opposite party. It is not necessary that you live together in a shared household at the time when you file a complaint under the DV Act. If at any point in time you have lived in a shared household along with the opposite party and were subjected to acts of domestic violence, it is enough to constitute shared household under this act and you can file a complaint. Parliament of India passed the DV Act to provide better protection to women against acts of domestic violence. So under the DV Act, various forms of abuses have been covered. First is physical abuse. If you're being physically injured or caused pain by your husband or his relatives, then you're being physically abused. If your husband or his relatives treat you or abuse you in a sexual manner which you do not approve of, then you're being sexually abused. It would include acts of forced sexual intercourse or showing you pornographic or obscene material which you do not approve of, or even child sexual abuse. Economic abuse. When you're not being given adequate money for your maintenance or living your day-to-day life by your husband or his relatives, then you're being economically abused. Verbal or emotional abuse. If you are being abused by your husband or his relatives for not being able to bear a male child, for not being of fair complexion or beautiful enough, or for not bringing enough dowry, then you're being emotionally and verbally abused. This act also covers mental abuse by in-laws or husbands. If you are an aggrieved woman and you have reason to believe that acts of domestic violence have been committed against you in past or are currently being committed against you, or there is a likelihood that in future such acts may be committed, you may initiate a case under this act. Now you've decided to take action against the acts of domestic violence and want to file a complaint. Where should you file a complaint? You can file a complaint in a court of local jurisdiction of the area where you temporarily or permanently reside, where you carry your business or are employed, or where the act of domestic violence was committed against you, or where the opposite party temporarily lives or carries on his business or is employed there. How to file a complaint under the DV Act? You can file a complaint by giving in writing or orally to the protection officer. Under the DV Act, every district has a protection officer. Or you can give a complaint in writing or verbally to a service provider. Service providers are private organizations or NGOs which have been appointed under the DV Act. Or you can directly approach the magistrate of your area and file a complaint. For this purpose, you may need help of a lawyer. And if you cannot afford a lawyer, please ask your protection officer to help you in getting free legal aid. If you have received any sort of injuries by the acts of domestic violence, you can yourself go to any hospital, either private or government, and get yourself treated. Or you can ask your protection officer to take you to the hospital. Even service providers are obligated to take you to the hospital and provide medical care. Either you or your relatives have given a complaint to the protection officer or to the service provider or to the magistrate directly. In the end, every complaint of domestic violence will reach the magistrate. On receiving the complaint, the magistrate will give you a first hearing within 3 days. And magistrate has to dispose of the cases of domestic violence within period of 60 days from the first hearing. Under this act, the protection officer is obligated to inform the other party about this complaint instituted against him under the DV Act. Under the DV Act, the role of a protection officer is of crucial importance as she is closely connected with the aggrieved party. So make sure that you provide all the necessary and important information to your protection officer, because it is only on the report of the protection officer which she submits to the case, the judge will decide a lot of things. The report which the protection officer submits to the court is called Domestic Incident Report. DV Act provides various protection to the women, including right to have their proceedings conducted in camera. So if you are uncomfortable because your proceeding is being conducted in an open court, you can request the magistrate for conducting your proceedings in camera. The magistrate can also send you or the other party or both of you together for counseling sessions. There are various types of reliefs provided under the Domestic Violence Act which a woman can claim in the court. The reliefs are compensation or damages for the injuries or loss you have suffered, right to reside in the shared household in which your husband and his relatives live, irrespective of the fact whether you have any right, title or interest in the shared household. Protection order can be claimed by you from the court. Under the protection order, you can ask the court to ask the husband not to bother you, not to hamper your peace, not to enter your area of employment, in case of a child, not to enter their school or a place which is frequented by them. You can seek residence orders from the court in case you do not wish to live in the shared household. There are several circumstances where the aggrieved party does not wish to live in the shared household. So you can make an application and you can ask the judge to provide a separate accommodation. The judge will pass a residence order in your favor if he is satisfied with the facts, and will ask the husband to bear the cost of your accommodation. The judge can even pass residence order prohibiting the husband from living in the shared household, or he can even ask the husband not to enter the area of the shared household in which you live. Next is monetary relief. The judge can make orders to the husband to pay some amount to you as an interim protection till your case gets disposed of, and later in the final relief, judge can order some sort of monetary relief. Then we have compensations which are given to an aggrieved party under this act. They can be in various names and colors, and you can seek them depending on your facts and circumstances. Lot of women face issues with respect to the custody of their children, so they can make an application to the judge regarding retaining the custody of their children, and if the judge is satisfied, he can ask the woman to have the custody of the child. Now we are in the last part of our video, and I wanted to tell you few important points regarding the DV Act. The reliefs which I talked about can be claimed by you in an ex parte manner. Ex parte means where the other party does not appear and the judge is satisfied upon facts and circumstances of the case. He can order these reliefs to you without hearing the other party. As I've already mentioned, these reliefs can be claimed by you in an interim order manner. Important to take note is that if you file a complaint under the DV Act, your husband or any of his relatives are not going to jail directly. But if they fail to comply with the orders which have been passed by the court under the DV Act, then the husband or his relatives may be subjected to 1 year of imprisonment or 20,000 fine or both. The offences on non-compliance of protection orders are non-bailable and cognizable in nature. If any of the relief has been given to you, then they will not be discharged automatically. They will only be discharged on your application or revocation. And in case if the judge has passed an order which does not go in your favor, you can make an appeal to a higher court within 30 days of the passing of that order. Now, these were the important points which I covered under the DV Act. I hope that I was helpful, and if you like this video, please do share and subscribe us. Thank you. To get your legal news fix, please subscribe to LiveLaw.